9:06. In the morning, Greenwich Mean Time. The crimson doors of the Privy Council chamber at St. James's Palace open, and King Charles strides forward without notes, without aides flanking him, without the prepared remarks that royal addresses of any significance are always built around. The correspondents in the room have covered enough of these moments to recognize immediately that something different is happening. He speaks for exactly 67 seconds. In those 67 seconds, he detonates 2 years of secrecy so completely that the room does not fully absorb what it has heard until the recordings play back. Years of patience have lapsed, he says. Archie and Lilibet deserve the stability we can demonstrably provide, and my advisors and I have reached full consensus on the lawful course to secure their welfare. The veteran correspondents are already filing as he walks back through the crimson doors. But the phrase that nobody in the room fully processes until they hear it again in playback, the phrase that the legal specialists across 2 continents will spend the following days unpacking, is not the declaration about patience or stability. It is 4 words buried in the middle of the statement: full consensus on the lawful course. Because full consensus on the lawful course does not describe a family's wishes or a grandfather's grief. It describes an operation. A coordinated, multi-jurisdictional, professionally staffed legal offensive that has been running in a sealed room above Gray's Inn for 24 months, that has assembled a 4-firm task force and a 4.7 million war chest, and that is now, as of this Thursday morning in the spring of 2026, poised to activate its final phase. The operation has a name. Palace aides confirm it within hours of the statement's release, understanding that the name itself is the next day's story and that controlling how it enters the public conversation is more valuable than concealing it. Operation Hearthstone, 3 phases. The first complete, the second already filed and docketed in a Los Angeles bankruptcy court. The third waiting behind a sealed petition in the High Court's Family Division for a single word from a California judge, a word that will determine whether 2 children currently sleeping in a house in Montecito wake up in the same house a month from now, or whether they wake up in a nursery at Kensington Palace with blue pajamas stitched with tiny crowns folded in a dresser drawer that has been waiting for them. The architect of this operation is a barrister named Alexander Marsden KC. She was once a moot court teammate of Prince William's at Oxford, a fact that the palace's communications team has been careful not to emphasize but has not exactly suppressed either, because it says something important about the quality of the person Charles chose when he decided that the institution's patience had reached its endpoint. She was sworn silk in record time after Charles retained her privately in March 2024. In the 2 years since, she has assembled evidence that reduces, in its most compressed and devastating form, to a single adjective: tolerable or intolerable. That adjective, when a judge in Los Angeles delivers it in open court, will either lock 2 childhoods in California or send RAF engines into the Atlantic sky. This is how it got to this point. This is the story of Operation Hearthstone, the 2 years of evidence assembly, the sealed room with biometric locks, the dismissed nanny whose testimony arrived on a rain-smeared Wednesday morning, the phantom donation line traced through Delaware shells and cryptocurrency wallets into new stone around a swimming pool, the 9 8-page brief filed in a bankruptcy court while California was still asleep, the unsent message on a dark phone screen, the blue pajamas in the dresser, and the barrister who whispered to a photograph of 2 toddlers in Kensington Gardens, "The law will bring you home." The day Alexander Marsden accepted the brief, she did not summon clerks or paralegals. She summoned cryptographers. In a nondescript suite above Gray's Inn Road, technicians installed an air-gapped document room with biometric locks and an offline server designed to store exactly 5 master files: litigation chronology, asset trace log, witness roster, psychological assessments, and the Hague petition draft. Every visitor to the room signed an official secret-style undertaking drafted by the Cabinet Office and countersigned at Windsor. Marsden's first rule was announced at the inaugural meeting and repeated at every subsequent one: leak once, leave forever. The room acquired a nickname within weeks: The kiln. Everything that entered emerged hardened. By April 2024, it was running 18 hours a day. Harbottle and Lewis messengers arrived with folios of forgotten Regency guardianship cases from the Lord Chancellor's archive. Cobry and Kim flew in blockchain printouts tracing coin tumbler hops between Delaware and Dubai. Blank Rome Associates provided deposition templates conforming to California's Code of Civil Procedure. Freshfields couriered margin notes from their Brussels partner who had successfully argued the El Ghazali case, the ruling that convinced a Belgian judge to uproot 2 children from Marrakesh despite furious press protests. Marsden digested everything, then reduced it to a thesis that she wrote on a single index card and pinned above the offline server. California will fail the intolerable test the moment its financial bedrock cracks in open court. Her nickname, the Velvet Guillotine, had been earned across 18 consecutive victories in high-net-worth divorce and international convention proceedings. The Velvet because she delivered outcomes with a precision and quiet that opponents rarely recognized as fatal until the moment of impact. The Guillotine because the outcomes were, without exception, fatal. Senior colleagues at the bar described her style as constitutionally allergic to theatrics. She never raised her voice in court, never produced a dramatic flourish when a documented fact would serve, and never underestimated the intelligence of the judge she was arguing before. American courts, she had observed to a pupil after one of her early California depositions, despise Baroque flourishes. They want arithmetic. She was prepared to give them arithmetic so precise and so thoroughly documented that no counter-argument could find purchase anywhere in it. The 4-firm task force she assembled was constructed around exactly that principle. Harbottle and Lewis handled 2 centuries of guardianship precedent buried in royal letters patent. Blank Rome secured standing in the Sussex Bankruptcy Court and laid the groundwork for California procedure compliance. Freshfields drafted the sealed Hague return petition and kept it updated as the evidence developed. Cobry and Kim pursued the money, reconstructing Archwell's ledgers with the forensic attention of investigators who have been trained to find assets that sophisticated operators have worked hard to conceal. What they found within the first 6 months of Phase 1 was a £3.2 million shortfall traced through Delaware shells and cryptocurrency wallets into a Montecito contractor's escrow account. The transaction records describe the destination with the specific clarity of a document that was never meant to be read by anyone outside the operation. New stone around the swimming pool. Phase 1 ran from March to October 2024. Its purpose was not to file anything or to declare anything or to make any public move that might alert the Sussex legal operation to what was being assembled. Its purpose was to build a case so internally consistent, so thoroughly documented, and so arithmetically airtight that no counter-argument could dislodge it once it appeared in court. Marsden understood that a single evidentiary weakness, discovered and exploited by Meghan's legal team, could unravel months of work and hand the narrative back to the people she was building the case against. There would be no weaknesses. The kiln existed to ensure that. The opening came on June 3, 2024, when the IRS served Archwell with a notice of proposed penalty for late filing. The sum was $32,000 trivial on its face, the kind of administrative friction that large organizations accumulate and resolve without significant disruption. Marsden did not treat it as trivial. She filed a Freedom of Information request the same week, named herself Public Interest Counsel for minor beneficiaries of the foundation, and obtained every redacted Form 990 that Archwell had submitted. Within the spreadsheets, her forensic accountant, Lydia Shaw, found the phantom line. A £3.2 million donation cluster labeled Community Outreach Pacific Region, appearing in the foundation's income records with no corresponding outbound grants, no beneficiary receipts, no documentation of how the money had been deployed in service of the charitable purposes the donations had been solicited for. 14 banking days after the cluster appeared in the ledger, the same amount surfaced as a wire transfer to Blue Lark Limited, a Delaware shell company. Shaw mapped the cash from Blue Lark through Kraken wallet transactions into the Montecito contractor's escrow account. The description field on the final transfer read, Pool Surround Renovation Stage 2 Completion, New Stone Around the Swimming Pool. Charitable funds that had been collected in the name of vulnerable communities had paid for luxury home improvements. The documentation was clean, complete, and devastating. July delivered the second fracture. A junior nanny, dismissed without severance, contacted Harbottle and Lewis through an encrypted portal established for exactly this category of witness. Her testimony landed on Marsden's screen at 2:14 inches the morning on a rain-smeared Wednesday. She described a domestic environment that had been organized around photographic opportunity rather than child welfare. Archie measuring hugs by camera shutters, Lilibet's playtime choreographed for drone overheads, the children's natural emotional responses managed and redirected when they didn't serve the visual narrative being assembled for publication. By breakfast, the statement had been converted into a California-compliant declaration under penalty of perjury, notarized at the British Embassy in Washington, and filed in the kiln's witness roster. Marsden made a note on the index card that she carried between the kiln and the court. Psychological harm married to financial harm. The Hague Convention respects patterns, not anecdotes. By September 2024, Blank Rome's attorneys had convinced a Los Angeles judge to allow limited discovery on the Sussex marital trust. The ruling cracked open a trove of wire receipts showing children's appearance fees coded as educational income, but feeding a joint lifestyle account that settled private jet invoices. The Coogan account review completed the picture. California's child performer law requires that a portion of any income earned by a minor in a commercial capacity be deposited into a protected Coogan account accessible only to the child upon reaching adulthood. The review found 0 Coogan deposits for Archie or Lilibet. Every dollar the children had technically earned through commercial appearances had been processed through accounts that served the household's operating expenses. Every dollar was, in the specific language of the statute, misappropriated. Marsden added 2 words to the index card beneath her original thesis: intolerable on stilts. The autumn months brought the commercial picture into sharper focus. A luxury watch brand quietly allowed its partnership option with Meghan to lapse without announcement. A production company withdrew from a documentary pitch, its insurance underwriters citing active litigation headwinds. By November, Meghan's publicist was receiving more fact-checking queries from journalists than interview requests. The narrative was no longer hers to drive. It had been transferred without ceremony to court calendars and creditor timelines where it would remain for the foreseeable future. Phase 1 closed by New Year's Day, 2025. Charles initialed every page of the executive summary. His comment to the courtier who witnessed the signing was recorded in the kiln's log. "We waited for them to right the ship. They drilled new holes instead." He authorized Phase 2. Dawn on the last day of February 2026. 2 federal bankruptcy clerks in downtown Los Angeles unsealed the day's motion stack in the routine way of people performing a routine task, expecting the routine contents of a bankruptcy docket. Nestled between standard creditor petitions sat a document that was neither standard nor routine, a 9-8-page, brief-headed amicus curiae submission of His Majesty King Charles III in Re Sussex Estate. The embargo that Marsden had maintained for 8 months broke at the precise moment she had chosen for maximum legal and strategic effect, while California was still asleep. While Meghan's legal team had not yet arrived at their offices, while the first person to read the document would be a clerk whose job was to process it into the record before anyone could intervene. The filing was viciously methodical. It opened with a 4-line declaration of standing grandfather, head of state, potential alternative custodian, interested party in the welfare of the named minors, and then moved directly into numbers. 23 invoices for private jet charters. 16 luxury goods purchases tagged as business wardrobe but charged to Archwell's operational accounts. 0 Coogan deposits for either child across the entire period under review. Every expenditure was tied to specific dates when online fundraising campaigns had been running campaigns whose explicit promise to donors was that the money would be used to empower vulnerable youth. Every promise was paired with a canceled check to Blue Lark Limited and a blockchain hash authenticating the subsequent transfer. The brief's closing sentence had been written and rewritten in the kiln across 3 drafts before Marsden was satisfied with its precision. Charitable intent ends where personal enrichment begins. The court has a duty to draw that line. California media ignited before the working day had properly started. Morning shows book legal analysts who described the filing with the specific astonishment of people who had covered royal affairs and American family law separately and had never imagined the two would be combined at this scale and with this level of documentary rigor. A former assistant U.S. trustee described the motion as custody by spreadsheet and predicted the judge would have no choice but to appoint a guardian ad litem. Meghan's spokesperson issued a counter-statement describing the filing as colonial overreach, an attempt to recolonize its own bloodline. Legal analysts responded with the uniformity of people who have spent careers reading international convention law. The Hague Convention is ratified by both nations and has no colonial subtext. The soundbite briefly inflamed social media. The arithmetic remained unchanged. The California Child Entertainment Commission confirmed in a written statement that no Coogan certificates had been issued to Master Archie Harrison or Miss Lilibet Diana Mountbatten Windsor. A Beverly Hills law firm representing Meghan made a quiet inquiry about settlement parameters. Charles's response, communicated through Marsden, accept nothing short of structural change. The whisper phase began in the days following the filing. The confrontations on the gravel path, the raised voices audible through French doors, the domestic drama that had been intermittently visible to staff and occasionally to telephoto lenses, all of it stopped. Harry and Meghan moved in parallel silences through a house that had become two separate operational headquarters. He to a rented office above State Street in Santa Barbara, where his new solicitor, Randall Keats, had established a working space. She to the mahogany-paneled library that had once staged their Spotify promotional videos, now serving a different purpose. Keats presented Harry with the reintegration accord across 8 uninterrupted hours of review. The document offered what Keats described carefully and repeatedly as a parachute rather than a cage. Sign before the hearing. Open Coogan trusts in Britain. Submit to a 12-month supervised review. In exchange, Marsden would withdraw any request for supervised contact after year 1. The Phase 3 Hague petition would be held in reserve rather than filed, and Harry would retain meaningful parental involvement in his children's lives within a framework that the court could verify and the palace could monitor. Harry asked for 48 hours to consider. The request collided almost comically with a docket clock that was running on its own schedule and had no mechanism for accommodating the emotional timeline of a father who needed more time than the law was prepared to give him. A paparazzi lens caught him on the gravel path 2 days later, phone raised, voice audible to the photographer at distance. The words that reached the lens were a request, almost a plea. Just sign the papers and we can argue later. The person he was speaking to refused. The photographer heard the refusal not as words but as what happened next. Glass breaking somewhere inside the house, followed by the slam of a side door. By afternoon, movers had arrived with a van. 3 items emerged: a walnut crib, a box of children's books, and a framed black and white photograph of Archie swaddled in linen on the steps of Windsor Castle. Harry had apparently chosen what to save first. Meghan declined to comment on the photograph's removal or its destination. Meghan's legal team chose the opposite tactic from quiet negotiation. They filed a press-friendly motion to strike the king's amicus brief as foreign sovereign intrusion, accompanying it with a statement that described the crown's intervention as an opaque attempt to recolonize its own bloodline. Legal analysts responded to the recolonize formulation with the specific amusement of people who find a legal argument so weak that its existence is itself informative. The Hague Convention is not a colonial instrument. It is a child protection mechanism ratified by both the United Kingdom and the United States, and designed precisely for situations of this kind. The motion's legal merit was thin enough to be transparent. Its strategic purpose to generate a media cycle that might temporarily displace the arithmetic at the heart of the amicus brief partially succeeded for approximately 48 hours. The math returned. Corporate oxygen continued to thin. The Beverly Hills private bank demanded an additional equity injection to maintain the credit line. A Paris fashion house postponed a capsule collection Meghan had designed, citing production financing that had failed to materialize. Archwell's website slowed its publishing cadence to a single bland post about digital citizenship that generated more sarcastic comment traffic than genuine engagement. 7 days to Judge Matt's hearing. The palace war room stamped every internal memo with a designation that communicated its operating assumption: urgent, assume, accelerated ruling. William resumed his normal public engagement schedule and Earthshot site visit, a mental health roundtable, but aides noted that every spare minute was spent scrolling courthouse updates on a secured tablet. Catherine reorganized 2 guest suites, adding child safety latches and nightlights bearing the royal arms. Asked by a staffer whether the preparations might prove premature, she replied with the equanimity of someone who has decided that equanimity is the only appropriate response to a situation this uncertain. We prepare for joy just as we prepare for grief. Methodically, Harry broke protocol on the 5th day and telephoned Marsden directly. The call lasted 12 minutes. He pleaded for a private conference with his father before lawyers made everything irreversible. A family summit, he said, that might produce the kind of understanding that no legal instrument could manufacture. Marsden listened to the full request, which was the specific professional courtesy she extended to everyone before declining, and then she gave no promises. She gave facts. The reintegration accord remained open and unsigned on a desk in Santa Barbara. The amicus brief's balance sheet arithmetic was irrefutable and had been on the public docket for weeks. The Coogan account vacuum was fatal and had been confirmed in writing by the California Child Entertainment Commission. The court would not defer to a family summit that had not happened in 2 years and showed no signs of happening in the 7 days that remained before the hearing. Harry ended the call with a sigh so deep that the secure recording equipment registered it as a volume spike in the log. 5 minutes later, a staff member heard him change the access code on his study door. The RAF Voyager completed a full crew rehearsal from North Holt to LAX and back, child welfare officers practicing in-flight procedures alongside 2 empty booster seats fitted to military-grade safety bases. The Home Office confirmed that expedited passports had been printed for Archie and Lilibet, unsigned, locked in the Foreign Secretary's red box. A civil servant, asked about the passports by a colleague, offered a formulation that traveled through the palace communications network by end of day. Paperwork is not pressure, but it reminds everyone that the switch exists. Poll numbers crystallized in ways that the Sussex communications team found difficult to absorb. A flash survey showed 86% of UK respondents and 58% of US respondents now viewing the King's intervention as reasonable if the court evidence stood. The figures arrived on Meghan's desk in the same hour that Chrono Crown served formal notice rescinding its last remaining endorsement. The revenue cliff that had been theoretical for months had become architectural. Montecito accountants were preparing a draft Chapter 11 filing against the contingency of an adverse ruling. Marsden, in the kiln, rehearsed oral argument with a 3-barrister firing squad, hurling hostile hypotheticals. She answered each in 25 words or fewer. At the bottom of her index card, she added the line she intended to deliver as her close in open court. Children are not assets. They cannot be leveraged in bankruptcy and left in trust that never existed. The evening of March 13th, 2026, the red phones in the palace war room stopped ringing. Everything that could be filed, briefed, rehearsed, and requisitioned existed in hard copy. The kiln servers had burned 3 encrypted drives, placed them in a diplomatic pouch, and delivered them to St. James's. The operation that had begun as a whisper in a nondescript suite above Gray's Inn Road had swollen into a dossier thicker than a Victorian railway timetable, and it was now in the hands of the people and institutions that would determine what it produced. Charles slept little. He rose before dawn to reread Psalm 82, defend the weak and the fatherless in the private way of someone drawing on a resource that is older and more durable than any legal instrument. At first light, he signed the final instruction authorizing deployment of the RAF Voyager within 72 hours of judicial order. The pen moved across the page and the ink dried, and no one in the room said anything for a moment that was slightly longer than silence usually lasts. A courtier who had served 3 monarchs would later tell a colleague that no royal seal had felt heavier since the abdication documents. In Montecito, the mansion exhaled what staff described as its last illusions. The removal van that had come for the walnut crib and the children's books and Harry's photograph had been a prelude. Now, the house was operating in a register that even sympathetic observers found difficult to characterize as anything other than end stage, not the end of a marriage, which had already passed some time ago, but the end of the specific project that the marriage had become after the departure, the project of demonstrating through sustained commercial and media production that the departure had been worth it. Bloomberg flashed an alert at noon. Archwell's principal bank had frozen the foundation's operating account pending a compliance review. The charity's website went into maintenance mode within the hour. Donation links redirected to a static banner citing technical upgrades. In the kiln, Marsden read the news and allowed herself the specific expression of someone who has predicted something precisely and has just watched the prediction arrive on schedule. At Kensington Palace, Catherine went to the nursery that evening and checked the fresh linen for the 3rd time that week. She lingered over a pair of blue pajamas stitched with tiny crowns, turned them over in her hands, and folded them back into the dresser drawer. Symbol, she had said to William the previous evening, of a welcome rather than a prophecy. Downstairs, William stood at the long window overlooking the gardens. A staffer brought news that Harry had neither signed nor rejected the reintegration accord. William's reply was soft but carried the specific quality of finality. Then the court will write one for him. The sealed diplomatic case on Charles's mahogany table had been there for 3 weeks. 2 blank child passports. A GPS-tracked custody order whose enforcement protocols had been drafted by the Home Office Child Safeguarding Unit and reviewed by Foreign Office legal advisors who specialized in the intersection of royal prerogative and international family law. The case's clasp was engraved with a designation that the monarchy's archival precision had assigned before the operation had formally been named EH1. Emergency Heirloom 01, even in extremis, the institution catalogs. Harry was on the Pacific coast, phone dark, the accordion unsigned. Earlier, he had walked the corridor lined with framed photographs of philanthropic work launches, initiatives, the visual record of a post-royal project that had been assembled with genuine energy and genuine belief that it would prove, over time, to be worth what it had cost. The photographs were still on the wall. The ledgers behind them were what they were. He had composed a message to his father on his phone and rewritten it 3 times and deleted 2 attempts entirely, and still could not find a formulation that said what he meant without conceding things he wasn't sure he was ready to concede. The draft that remained on screen when he set the phone down read, "Whatever happens, keep them safe." He could not bring himself to press send. He set the phone face down on the table and looked at the Pacific, which continued to move the way it always moved, indifferent to the specific human crisis unfolding in the house behind him. Princess Anne chaired the logistics briefing at the Royal Mews with her customary efficiency. The staff worked through a hypothetical flight plan. RAF Northolt to LAX, 72-hour turnaround, security detail of 6, 2 child welfare officers with pediatric first aid certification. Anne reminded the room that the plan remained academic. Then she issued the instruction that told everyone in the room what she actually understood the plan to be. Preposition child-sized life vests in the Voyager's forward cabin. The room processed the instruction with the professional composure of people who have served long enough to understand that the gap between academic and operational is narrower than it sometimes appears. Marsden conducted her final moot in a curtained hotel suite near downtown Los Angeles. 2 junior barristers assaulted her with hostile hypotheticals for 3 hours. What if the Sussexes open Coogan accounts tonight? What if Meghan announces repayment of the £3.2 million shortfall? What if Harry signs the accord at midnight? She answered each in the 25 words or fewer she had trained herself to use, then closed the folder. Remedial gestures on the courthouse eve do not erase years of statutory breach. She had said the sentence so many times in rehearsal that it had acquired the quality of something much older than the case it had been written for. She slid the index card into her robe pocket. Charles, awake in the bow room, allowed himself one private sentence unbeholden to counsel or cameras. Let the truth be plain. I have no wish for victory, only for refuge. The entire operation had been constructed around the specific legal meaning of a single adjective under California Family Code: tolerable, intolerable. These are not moral assessments. They are statutory conditions defined by a set of welfare metrics that courts apply to determine whether a child's current living environment meets the minimum standard required for that child to remain in that environment under that parent's care. The distinction between them is not philosophical. It is measurable. It is documented. And once a court finds that an environment is intolerable, once that specific word appears in the minute order, a sequence of legal consequences follows with the automaticity of a trigger mechanism. A finding of intolerable environment empowers the California court to appoint a guardian ad litem and to treat the children as requiring protective placement. This is the door that Phase 2 was designed to open. Once it opened, Phase 3 would activate within 48 hours. Marsden would unseal her petition in the High Court's Family Division, arguing that Archie had been born in Britain, had been wrongfully retained abroad, and that both children must be returned under the Hague Convention to appropriate care in the United Kingdom. The legal instrument of supervision would be the Crown Guardianship Act of 1772, dormant since it was last invoked during the Regency crisis, never repealed. The order already drafted by palace solicitors and sitting in escrow at St. James's, awaiting a single judicial nod from California. Marsden's closing argument for the Phase 3 filing had been written in the kiln and refined across 11 drafts. California offered shelter. The Sussex estate traded it for spectacle. This court must restore what conscience stripped away. The word tolerable would mean something different and considerably more patient. The children would remain in California. The operation would pause. The Hague petition would stay sealed. The palace would wait for the next breach, the next evidentiary fracture, the next financial collapse that provided grounds for a renewed application. The institution had waited 2 years already. It could wait longer. It had been waiting longer than any of the individuals involved had been alive, and it understood patience the way organizations understand things they have practiced for centuries. Marsden had been clear with Charles about both scenarios. The operation was not designed to guarantee a specific outcome. It was designed to make the intolerable finding inevitable if the documented evidence was presented accurately. The evidence had been assembled with 24 months of professional precision. The presentation was her job. The adjective was the judge's. Court would convene at 8:30 the following morning. No remote appearances permitted. The clerk's schedule had been uploaded to the public docket at midnight, and the correspondents who had been covering the case for weeks had been refreshing the page with the specific vigilance of people who understand that the document they are waiting for will appear without warning, and that being the first to read it matters. In London, Big Ben chimed the hour over a city that was, for once, paying closer attention to a courtroom in California than to anything happening in its own streets. Charles had closed the Psalter and signed the deployment authorization and was sitting in the bow room with the specific stillness of someone who has done everything that can be done and is now in the condition that follows: waiting. The sealed diplomatic case with its EH1 clasp sat on the mahogany table 3 feet from where he was sitting. He did not look at it. He looked at the window and the darkness beyond it and thought, if his courtier's account of the evening is accurate, about 2 children who did not know their names were on the documents inside. Harry's phone screen had gone dark sometime after midnight, the unsent message still in the drafts folder. The Pacific continued outside the windows of the Montecito house, moving the way it always moved. The house was quieter than it had been in months. The removal van had taken what it took. The bank had frozen what it froze. The docket clock had run its course. There was nothing left for impulse to operate on. What remained was paper, the 9 8-page amicus brief in the bankruptcy court docket, the sealed Hague petition in the High Court's Family Division, The Crown Guardianship Act of 1,772 inches, the statute books, and the reintegration accord on a desk in Santa Barbara that had been open for weeks and carried no signature. Marsden, in the hotel suite, extinguished the last light. She had done everything that could be done in the kiln and in the courtroom prep rooms and in the California depositions and in the encrypted communications with the four-firm task force. She had reduced 2 years of evidence to an index card, 25 words or fewer per answer, and the closing sentence that the court would hear tomorrow. She had rehearsed her close until it landed in 25 words or fewer with the force of something that had taken 2 years to build. She paused at the door and looked at the last thing she had placed on the table before she left. A photograph of 2 toddlers in Kensington Gardens, taken long before the acrimony set in. Taken when the story was still a story about a prince in a beginning, rather than a prince and a reckoning. She had looked at it most evenings since the kiln opened. The children in it were unaware of the room, the operation, the index card, the 98 pages, the empty booster seats in the Voyager's forward cabin, the unsigned accord, and the blue pajamas in the dresser at Kensington Palace. They were just 2 children in a garden. She whispered to them, as she had whispered most evenings, the sentence she had written for herself rather than for the court. The law will bring you home. Whether she would be right, the morning would determine. Whether the adjective would ignite jet engines or descend into silence was the judge's choice, not hers. But the case was made. The evidence was immovable, and the institution that had commissioned it had been making cases like this, in one form or another, for 1,000 years. Paper outlasts impulse. The law endures, and in a courtroom in California, at 8:30 the following morning, a single adjective was about to be chosen that would echo across 2 continents and determine, for the foreseeable future, where 2 children ate breakfast.